And today, just continuation of what we did last week, we'll be talking about licenses as relates to creating and using open educational resources. And I really hope today will be like, we'll have a really interesting session today. So I'll be breaking the session in like 3 parts. So after the first part, I'll give room for questions if there are any before we go to the next part, and then concluding. So I'll just share my screen now. So please, I'll need a confirmation if you are all seeing my screen.
Yes.
Okay, thank you very much. Okay, so can we please mute? Can we please mute our mic? Thank you. Okay. So today we'll be talking about copyright, licensing, and the public domain. And this is a very important topic when we are talking about open educational resources or talking about intellectual materials in general. Because, okay, let me just go through so that I'll just explain as we go through. So understanding copyright and intellectual property. Before I talk about copyright, I'll talk about intellectual property because intellectual property is like the body that covers copyright. So intellectual property refers to the creation of the mind. So the way we have landed properties, we have cars, we have jewelries, we have clothes, we have things that we own. We could also own intellectual resources. We have C of O's that shows this landed property belongs to me. Same way we have copyright, patent, trademarks that shows that an intellectual work belongs to me. So it refers to the creation of the mind, something that you have conceived, something that you have thought about. It could be inventions, it could be art, it could be designs, it could be names, it could be writing. So this is related to writers, authors, people that create software, people that if you have a brand, like your brand, your logo, your motto, just anything that you've thought about, you've given some thought to it, and it's something original that you have created. These are all intellectual properties that are legally protected. So IP, which is intellectual property, it gives creators exclusive rights to use, sell, or license their works. And it prevents others from stealing or copying it without permission. So the same way you own a piece of land and then you have the documents to show that this land belongs to me. So someone else cannot come tomorrow and say, I'm the owner of this land because you already have the document that proves that the land belongs to you. Same way, intellectual property gives you an exclusive right to do whatever you want to do with your intellectual work, and it prevents others from stealing or copying it. So if you're a musician, you've created a song before, and then you realize that your lyrics is being used by someone else, and you have intellectual property rights over your lyrics, you could, sue whoever it is for infringing on your rights. So that's what intellectual property gives. It gives you an exclusive right to do whatever you want to do with your work and to also prevent others from stealing or copying it without your permission. So the common types of intellectual properties we have are patents. These are for innovations. We have copyright, which is what we'll be focusing on since we are talking about written works, mostly for OERs. Not just written works, art, music, videos, audiovisuals. These ones are what are related to books. Trademarks for brands or logos. So if you have like a business, you have a brand, you have a logo, you have a symbol or an icon or something that is specific to your brand, you have trademarks for it to show that this is something that belongs to you. And we also have trade secrets that's for confidential business information. So now we'll be dwelling on copyright, which is just one type of intellectual property, but that's what is related to us in respect to open educational resources. So copyright is a legal protection for original creative works like books, music, art, films, and softwares. Now, if you see original is written in bold because it's very important for your work to be original. You cannot copy somebody's work and then claim copyright over a copied work. It doesn't work that way. And one mistake or one uh, something that people do mix up is copyright and copywriting. So we have copyright as in COPYWRITE. So that is the writing of copies. That is more related to those who are in the writing line, SEO, content creation. So that's writing of copies. But this copyright we are talking about is RIGHT. So copyright is like the right you have to a copy, the right you have to a creative work, the right you have to an intellectual property. So that is what we are talking about, not copyright as in writing a copy. So that's just to clarify that. So it's a legal protection for original creative work. That means it has to be original. It has to be yours. I cannot just take a textbook, copy like a chapter of it and say, I want to copyright that work and say it's now mine. It doesn't work that way. It only protects original creative works, giving the creator exclusive rights to control how their work is used, copied, or sold. So as an original creator, copyright gives you an exclusive right to own your work, to control whatever is being used, reused, um, how it's being downloaded, if it's an online work, how it is being transcribed, how it is being translated, anything that anyone wants to use it, you have exclusive rights to it. And so others must gain permission to use it or they would face legal consequences. It's just a shame that our copyright law is not really enforced in a country like Nigeria because for someone who infringes on your copyright, they could face legal consequences. We have copyright laws, which I'll go into now. So according to the Nigerian copyright law, a copyright lasts for 70 years after the death of the creator. That's for books and for written manuscripts. So taking Chinua Achebe, for instance, he died in 2013. So copyright lasts for the whole lifespan of the author. That means from the moment the author writes a book and publishes the book, the author has copyright until the day he dies with an addition of 70 years. So because Chinua Achebe died in 2013, the copyright of his books lasts throughout his lifetime and 70 years after his death. So the copyright of his book would expire in 2083. So for a written work or a written manuscript, the copyright law protects you for throughout your lifetime and also 70 years after the death of the creator. And then for other creative works like sound recordings, painting, artworks, the copyright, uh, you have copyright for 50 years after the first publication. So this one is not dependent on the death of the author. If it is published today, it expires, the copyright expires 50 years after today, that's 2075. So imagine I create an artwork today, this is 2025, right? Okay, so 70 years after today is going to be 2090, 50 years rather, is going to be 2075. So the copyright of a work that was published in 1976 now, the copyright would expire in 2026. So for recordings, sound recordings, audio visuals, painting, artworks, you have 50 years from the first publication, you have copyright for 50 years. And then for written works, you have copyright for throughout your lifetime and 70 years after. So now what is the public domain? The public domain refers to creative works to which no intellectual property law applies. So this is like a direct opposite from copyright where we are coming from. Now copyright gives you exclusive rights to an intellectual property, meaning all rights are reserved. I would show a picture later during the slides how you would see it at the back of the title page. When a work is copyrighted, all rights are reserved to the owner, to the creator. But with public domain now, no right is reserved. Public domain refers to works to which there is no copyright, there is no patent, there's no trademark, there's no intellectual property law to this work. This means that anyone can freely use them, they can freely copy them, they could modify them without needing permission or paying fees. So you can see that this is like a complete opposite of copyright. This one gives you exclusive access, it gives you free access, completely free access to use a work without needing permission, without infringing on any copyright, without infringing on anybody's rights, and without paying any fee. So you can freely access works that are in the public domain. So now how the works enter into the public domain? And for just to state, if you are trying to create an OER, these are places where you could get works to create OERs. Public domain is like an endless treasure, an endless storehouse of intellectual works that you could use, reuse, remix because they have no rights attached to them. So you could use them to create even more works. So how do works enter into the public domain? When the copyright expires, like I previously explained in Nigerian's context, 70 years after the death of the author for books and written works, and then 50 years after the first publication for sound recording, artworks, and images. So when the copyright of the work expires, that's when, like Chinua Achebe's works now, once it's 2083, his works enter into the public domain. So that is how some works go into the public domain once the copyright expires. Some people do renew copyrights, but people are advised not to renew their copyrights because you've had more than enough time. Because, I mean, 70 years after the death of a person can last even up to the third generation of that person. So you've enjoyed an exclusive right to that work. So it's just like you could now release your work to the public for public to make modifications to your work, public to use your work to create even newer works. Another way works enter into the public domain is if the work never has copyright, because there are some things that do not have copyright. Things like ideas. I can sit down now and think of something, and then tomorrow I go online and I see someone thought of the exact thing I did. I thought of rather. I can't sue that person for infringing on my copyright because that was just an idea. I had not written it down. When I write it down, then I can claim copyright on it. But if it's just an idea in my head and I see it online with someone else having that same idea, that person has not infringed on my copyright because it's an idea. Idea do not have copyright attached to them. Facts, things that are facts, they do not have copyright. Now, the color of Nigeria's flag is green, white is green. I can't say that that is my intellectual property. You can also say the color of Nigeria's flag is green, white is green. Does not mean you are infringing on my copyright. That's just a fact. It's something that is certain. We all know it. So facts are not copyright. They are not copyrighted. Sorry. Giving names, that's the name you bear. That's how you could see a million people bearing John, 10,000 people bearing Mohammed, 50,000 people bearing blessing. A lot of people can bear. So it's not like once I bear this name, my name is Olubusola, nobody else can bear my name. If not, you're infringing on my copyright. It doesn't work that way. So giving names cannot be copyrighted. That's why a lot of people can bear same names without infringing on any copyright. We also have phrases like the patient dog eats the fattest bone. Those like idioms, things like that. I can't copyright them because I didn't come up with them. It was just it's an idiom that someone came up with, but it is not copyrighted. I can use them in my book. Using that phrase does not mean I have infringed on anybody's copyright. It's just something that does not have a copyright. So things like these ideas, facts, giving names, phrases, they cannot be copyrighted. So they are automatically in the public domain. Also, government publications are also in the public domain. Things that are published by, just to note, by the federal government, state and local government works could have public domain, but things that are published by the federal government of the country are not in the public domain, except they are classed confidential or secretive. So if something is published by the Federal Ministry of Information, that work should automatically be in the public domain because it's published by the federal government. It is assumed that it's taxpayers' money that are used to publish this work, and so they are in the public domain. And also, we have voluntary donations. Some creators voluntarily release their works into the public domain. So I can choose to publish a work today and then just choose to dedicate it. We call it public domain dedication. And so there's like a special license to that. I can choose to dedicate my work into the public domain. I don't have to wait for 70 years after my death for it to go into the public domain. I can choose that, okay, well, I'm creating this work, but I don't want to have any copyright in it. I want people to use it freely. I want people to modify it, to edit it, to remix it, and just use it in whatever the way they choose to. I would want people to use that. So I can choose to donate my work into the public domain. That is another way works enter into the public domain. So how can I find works in the public domain? There are a lot, there are a million and one places you could find public domain works online. And these are just a few that I'm just going to show. And later on, I'm going to show like practical examples of how you could identify these ones. We have the Internet Archive, we have Wikimedia Commons, you could find public domain materials there. We have Europeana, we have Library of Congress, you could find public domain works there. We have Flickr Commons, we have Project Gutenberg, you could find public domain materials there. We have the Public Domain Review, we have publicdomain.ng, which is also a project run by Free Knowledge Africa. You could find Nigerian public domain works there. So before I go into Creative Commons licenses, I don't know if there's anyone that has any question so far. I don't know if there's any questions so far regarding copyright and the public domain. I'll just give like 1 or 2 minutes trying to check the chat if there's any question there. Okay, so if there is no question, I would just continue. So Creative Commons licenses. Now we've talked about copyright, we've talked about public domain. So copyright, as you can see from my screen, I have no rights reserved and all rights reserved. Like I said, no rights reserved is the public domain. So they are like on a spectrum, and copyright and public domain are on two opposite ends of the spectrum because they are like two opposites. Copyright states that all rights are reserved, which is the one by my right hand side. All rights are reserved to me as the creator of the work. I have every single right on the creative work. And then on the left hand side, I have no right to reserve, which is the public domain. I do not own, nobody owns works that are in the public domain. Anybody can use it anyhow they wish, anyhow they want to. But with copyright on my right hand side, you have to seek permission of the owner of the work. So now, because they are on two extreme ends, we have something called the Creative Commons licenses, which are some rights reserved. So this kind of bridges a gap between copyright and public domain. It kind of brings like a loophole to someone who doesn't want to go on both extreme. And now as someone that would, if you are trying to make like your capstone project at the end of this training, and then you're trying to look for works, you could find works that are CC license. They call them CC licenses, Creative Commons licenses. You could find works that are CC licensed. And then just knowing, understanding the licenses and understanding how to use them would help you very well so as not to infringe on the copyright. So now Creative Commons licenses gives everyone from individual creators to large institutions a standardized way to grant the public permission to use their creative works under copyright laws. So it gives the public a standardized way. It gives you like instead of thinking, can I use this work? Can I not use this work? You get to have an idea of, okay, this is how far I can use this work. This is what I can or what I cannot do. So with the various CC licenses available, creators can choose how and to what extent their work is being used. And so this is going to be useful to you as an educator, as a teacher, as a creator, in both ways, in using and in releasing. Now, in using, as if I find a work I want to use, I can know to what extent and how I can use this work. And as a creator of a work, I can know to what extent and how someone else can use my work. So this provides a middle ground between the traditional copyright that we have talked about and then the public domain. So we have 6 Creative Commons licenses, and these are 6 of them. We have the CC BY, CC BY SA, CC BY NC, CC BY NCSA, CC BY ND, CC BY NCND. These are just like abbreviations, and then I'll just run through all of them one by one. But one thing I want you to notice is in all 6 of these licenses, we have BY as a constant in all of them. And here, by means attribution, meaning for every Creative Commons license, you have to attribute the owner. Yes, you can do whatever you want to do with it, but you have to give credit to the owner. Now, this is different from public domain. With public domain works, you are not even mandated to credit the owner. I can see a work and use it without even referencing that, okay, it was this person that wrote this work. That's the sweet thing with public domain. You are not even mandated or advised to you're not mandated rather, but you are advised because it's common courtesy to say, okay, this work was written by someone. But even if you do not attribute that person, you do not give credit to that person, you are not infringing on any rights because it is in the public domain and it belongs to nobody. But with Creative Commons licenses, you have to, that is like the condition attached to them. So all of these are conditions, that people add to their works on how well and to what extent you could use them. So I'll just start with the first one, CC BY. Now with this license, it has just one condition. Creators and credit must be given to the creator. So this license allows you to reuse, distribute, edit, adapt, or build upon materials as long as you give credit to the creator. So that means you could use this work the same way you could use a public domain work without restriction, but there's just one condition. I have to credit the creator. So I can do whatever I want to do with this work. I can remix this work. I can create adaptations from this work, but I have to give credit and state that this work was originally created by so, 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 and so. That is just the condition I have to fulfill, and then I can do whatever I want to do with this work. So even as a creator, if you are creating an OER and you want to publish it under this license, all you are telling the public is that this OER I've created now, you can use it as you so wish, but I just want you to credit me that this is my work. It was I am the one that came up with this work, and then you can do whatever you want to do with this work. As someone that's looking for resources to create an OER, if you see a work like this, you know that okay, I can use this work, but I have to give sorry, I can use a work like this, but I have to give credit to the owner of the work. So that's the only condition that this license requires. So the next license is CC by SA, which is attribution share alike. Now, unlike the first one, this one has two conditions. By, which I said was a constant attribution for every CC license work. Attribution is a constant. Credit must be given to the creator. But now the second condition here is adaptations must be shared under the same license, meaning this license allows you to reuse, distribute, edit, adapt, or build upon materials as long as you give attribution to the creator, and any created or modified work must be shared under the same license that governs the original work. This means, yes, constant, I am giving credit to the author, but as much as I'm giving credit to the author, I have to fulfill the second conditions, which means I have to share it under the same terms. Now, I cannot use a CC, if a work was licensed under CC by SA now, I can't make a modification of it and then go and copyright that work. If I'm copyrighting that work, I am infringing, I am not respecting the condition under which. So I cannot use an open licensed work and then go and copyright a work I adapted through it. I also have to release it under an open license, under a CC license. I don't know if that makes sense. So yeah, I'm sharing it in the same like manner how the original work was shared. So if I'm using a work that is licensed CC by SA, I am giving credit to the author and I'm also releasing whatever work I create out of it under an open license. I can't gatekeep it and copyright it. So now the third license is CC by NC, by a constant, and NCS stands for non-commercial, meaning only non-commercial use of the work is permitted. So this license allows you to reuse, distribute, edit, adapt, or build upon materials only for non-commercial purposes as long as attribution is given to the original creator, which is like the constant. So if I see a work that is licensed CC by NC, meaning I can only use it for non-commercial purposes, which is perfect for open educational resources, which is perfect for open exhibitions, open works that I am not making any money out of. The moment I use a work that is licensed CC by NC and I start making money out of it, I am infringing on that copyright. I am infringing on rather the right of the owner of the work because the condition clearly states it has to be non-commercial. Now the fourth is attribution, non-commercial, share alike. So this one has three conditions to them, and it's just like a combination of two of the conditions, which is three rather, by which is a constant attribution, non-commercial and share alike, meaning I cannot use it for commercial purposes and I also have to share it under the same terms. Now, why this is different from the previous one that is just CC by NC is that there was no a share alike clause. There was no share alike clause. So in as far as I'm using it for non-commercial purposes, I don't necessarily have to publish it under the same license, that is the CC license. But if it has a clause of share alike, I have to share it under the same terms. Any adapted work I use must be shared under the same terms. So this license allows you to reuse, distribute, edit, adapt, or build upon for non-commercial purposes, one, as long as attribution is given to the original creator, two, and then all created and modified work must be shared under the same license that governs the original work, three. So all three conditions must be met for this license. This is the fifth one, attribution non-derivative, that's CC by ND. It also has two conditions, by which is the constant, attribution must be given. And yeah, non-derivative means no derivations or adaptations of the work is permitted. Now, this means I have to use the work exactly how it was used. So imagine I see a work that was written in Yoruba language now. I cannot make a translation of that work and use it in my imagine I'm creating like an OER and I see a quote or I see a saying by somebody that was published under a work with this license now, and that saying or that quote was written in Yoruba language. I cannot just make a translation of it. If I want to use that quote, I have to copy that quote as it is in Yoruba, insert it into my work, then maybe in the next line I'll now write this translates to and then give it my English translation. But I cannot just do a translation and then come and quote it because that person made that quote in Yoruba language. I cannot make that quote in English and say this was quoted by that person, even if it is a translation. But because the the work was published under non-derivative, that is the condition. You have to use it exactly how I used it. Imagine using like a picture, a photograph of a couch or a sofa, a brown sofa. If I want to use that couch, that brown sofa now, I have to use I cannot edit, with other licenses you could edit the image, you could make adaptations of the image. But if I want to use that couch and is published under non-derivative, I cannot change the color of that couch. That photograph was taken of a brown couch. If I want to use that couch, I cannot change that couch to like a black couch or a purple couch or a gray couch. I have to use it as a brown couch. Now, most people that use these licenses are people that have sentimental or personal, there's like a backstory towards their creation. So maybe that brown couch now there's a story behind it, and then that color, that brown is unique to it. And so they want that whoever is going to be use this work, it has to carry that brown couch, that brown color. It's very unique to my work. So I'm going to use non-derivative so that nobody can change the color of that couch from brown to any other color. Just like the saying, if that saying was said in Yoruba language now, maybe there's a special weight the Yoruba adage, let me just say adage or saying gives to it, and I don't want it to be watered down by being translated to English. And so I published other non-derivative. So even if you are going to translate it, you have to include that saying in the original form. So you cannot make any changes to it whatsoever. If I'm going to use a work that is published under CC by ND, I have to use it in the exact form, exactly how it was used by the original creator. Uh, okay, sorry. And so these are the six licenses. Like I said, attribution, CC by, attribution share alike, CC by SA, attribution non-derivative, attribution non-commercial, attribution non-commercial share alike, and non-commercial non-derivative. And so if we can see attribution, which is the one condition, it's closer to the public domain because the only difference from attribution and the public domain is just giving credit to the original author. And then this one, non-commercial, non-derivative, which is a combination of the two, the most strict licenses, meaning I cannot make money from it and I have to use it in the like manner how it was created. It's more closer to copyright because there's little to no changes I can make to it. So these are the six licenses. So if you see a work published under these works, you have to understand the condition that this license is hold to know to what extent what I can do with it. So what I can do with a CC by NC work, I may not necessarily be able to do it with a CC by SA work. Because if I'm creating a work that I want to sell, like a t-shirt now, and I want to put that picture or that saying in Yoruba that someone had written, and I want to like print it on a t-shirt, I can print that t-shirt for myself to wear at home, for myself to wear out. But the moment I sell that t-shirt, if it was licensed under non-commercial, I am infringing on that right because I am not supposed to make any money from it. But if it was published under attribution share alike or CC by attribution alone, I can sell it, I can make money from it. So it's very important to understand the licenses by which a work is published under to know how well you can use them when trying to create another work from them. And so the 5 hours of open educational resources, which you will see are all in line with the open licenses we previously discussed, are retained. You must be able to make, own, and control a copy of the resource. You should be able to download your own copy. If I'm able to download it, that work is most likely an OER. I should be able to edit, adapt, and modify a copy of that resources. That meaning I should be able to translate it into another language. That work is most likely an OER, except it has that clause of non-derivative that we spoke about. Then I cannot translate. I can translate it, but then I have to write it in the exact format it is. Then I translate it. Remix. I should be able to combine the original work or the revised copy of the resources with another existing material. So the way you make a mashup of a music, where you make it like a medley, joining different songs together, joining different. I could combine two folktale stories, and then come up with a whole story of my own. Come up or take a character from a story, take another character from another story, and then put them in my own story. If you are allowed to do that, you're allowed to remix a work. That work is most likely an open educational resources. Reuse, I'm able to use the original, revised, or remixed copy. I can use it in a class. I can use it to create a textbook that I can use to teach students in a class. If I'm able to reuse it, that work is an open educational resources. And redistribute, I'm able to share copies of the original, revised, or remixed copy of the resources with others. Sorry, post online or share with a class. So if you're able to do all of this, if you're able to retain, revise, remix, reuse, and redistribute, most likely that work is an open educational resource. And also, if you are creating your own open educational resource, others should be able to retain, revise, remix, reuse, and redistribute them. So these are some of the popular organizations that we know about that uses Creative Commons licenses. YouTube uses it, Wikimedia Commons, Wikipedia, Vimeo, Internet Archive, Europeana, Free Music Archive, Tribe of Noise. These are some of the organizations. Like, you may be surprised how a lot of organizations now like shy away from the traditional copyright and instead uses Creative Commons licenses instead. So I was saying I will show you a practical picture of what it looks like. So now on the left-hand side, if you take a textbook, if you take a book and you turn to the back of the title page, this is most likely what you are going to see. That's the left-hand side. You see copyright 2017, which is the year that it was published, Jane Doe, which is the name of the creator. And then you see all rights reserved. No part of this publication will be reproduced, redistributed, or transmitted in any form or by any means, including photocopy. So, even photocopying a work, photocopying a book, you are infringing on the copyright of that work. But because copyright law isn't taken too seriously in our part of the world, that's why a lot of people just get away with most of all this. Because you see, you cannot do anything, including photocopying, recording, or other, even taking like a picture of a book and creating an online PDF of that book. If that book is copyrighted, you are not allowed to do that. You are infringing on the copyright of that work. Except in the case of brief quotations embodied in critical reviews or certain other non-commercial uses which are permitted by copyright law. So for permission request, you have to write to either the publisher and address it attention permissions coordinator at the address below. So if I want to do any of all these that listed above, I am supposed to either reach out to the publisher or the author of that work before I am allowed to do anything with a work that is copyrighted. That is how strict copyright is. It gives exclusive rights. All rights are reserved to the owner of the creative work. So for every little thing you want to do, you have to seek permission. But on the right hand side, this is what you will see on a work that is licensed under a Creative Commons license. You see, this work now that I use as an example was licensed CC by SA. This work is licensed under the Creative Commons Attribution Share Alike 4.0 International License. And the good thing about CC license is there's always a link. So if I see CC by SA and I cannot remember what does CC by SA stand for, I can see it, Creative Commons Attribution Share Alike. But okay, Attribution Share Alike meaning what? What can I do and what can I not do? There's always a link. And if you go to the link, you will see what you can and what you cannot do with this particular license. So this is the difference. This is copyright, a work that is copyrighted. This is how to, if I'm trying to create a work or I'm trying to use a work, I go to the title page of that work. This is how I can identify a work that is copyrighted versus a work that uses CC licenses. A work that is copyrighted, you always see all rights reserved, and you see the copyright symbol. A work that is CC licensed, you see the CC symbol with the particular conditions or the particular license by which it is created. So I would give room for questions now before we go to like a practical session of how to identify these works. So I don't know if there are any questions. Okay, I'm seeing some on the chat box. Okay. My question is about works originating from public domain sources. Doesn't remixing them create new works that attract new licenses? Yes. If I find a work in the public domain, right, and then I create a new work, I am at liberty to do whatever I want to do with that work. I can choose to create a new work and copyright that work. I can choose to create a new work and use a Creative Commons license on that work. I can choose to create a new work and dedicate it also to the public domain. So public domain works do not restrict you. It's just like an ocean of works. You fetch the water and you use that water to do whatever it is you want to do. So creating new works from them, yes, they do attract new licenses, but you're at liberty to choose what license you want to release that work under. Do you want to copyright that work? Do you want to release it under a Creative Commons license? Probably share alike, or probably non-commercial, or probably non-derivative. It's all dependent on you. I don't know if that answers the question, Geoffrey. Seeing another question. I provide. Okay, this is my question. What is the difference between copyright and CC license? Okay. The copyright reserves every single right to you. And so let's take for instance, I create a work and I copyright my work. Meaning for every single thing you want to do with that book, you have to seek permission from me, no matter how little it is. Even taking a picture of that work, making a photocopy of some pages in that book, you have to seek for permission from me before you can use that work if your work is copyrighted. But Creative Commons licenses kind of gives you a little flexibility that, okay, I don't want to be so rigid with my work that it's only I have exclusive rights. I want to release some rights. So I now choose I should use six licenses. I now choose among those six licenses, what better suits me? Like what would pay me more? It depending, okay, now I created this work. I want people to use it, but I don't just want them to make money out of it. I can release it under a Creative Commons license, which is CC by NC. So I just place that condition of non-commercial on it. So you can use that work. All rights are no longer reserved. The only right I'm reserving to it is the commercial rights. I'm reserving commercial rights to myself. So as much as you can use it, you cannot make money out of it. If it's like a photograph that has sentimental value to me, I'll release it under Creative Commons, maybe CC by ND, non-derivative. Meaning, yes, you can use my photograph, you can print it on a shirt, you can make it the cover page of your textbook, but it has to be the exact photograph I use. You can't make any changes to the photograph. So that's the difference. Copyright reserves all rights to myself. Every single right, even the smallest of rights, is reserved to me as the owner of the work. But Creative Commons licenses gives me a series of licenses by which I can release that work, hold some conditions to myself, and hold some rights, sorry, to myself and release some rights to others. I don't know if that answers your question, Gift. I can see Adeola's hand raised. Please, you could ask a question.
Good afternoon. My name is Adela Desri. My name is Teneric Adela Desri. I want to ask a question about copyright. How you signify that your work is copyrighted by putting a copyright symbol on it, and how you signify that your work is CC Creative, using the CC Creative Commons is to Creative Commons CC is to also put
Creative
a
Commons license.
Creative Commons license, also put a sign on it. So, how do you now, um, let's say somebody takes advantage of your works, what do you now do? they don't
Okay.
seek permission.
Okay. Thank you. So on how to, according to Nigerian copyright law, once you publish your work and you do not state a counterfeit license to it, your work is automatically copyrighted. Like all you just need to do is when publishing your book, just like I showed, let me try and go back to my slide. Just like I showed in this picture, all you just need to do is make sure this statement, sorry, by the left hand side is is behind the title page of your work. So it shows this work is copyrighted. This work has copyright. This is like a proof that my work is copyrighted. Now, if I publish a book, right, and then I do not put this in on my book, I do not put this on my book, but I intend for it to have copyright because according to Nigerian copyright law, as the moment you publish your work automatically has copyright. Your work still has copyright, even though this is not there, but it's going to be very misleading to a user of your work because if I pick up a book now and I do not see this page, I could just assume this work is not copyrighted and then I use it without knowing that I'm infringing on your rights. Except to come out publicly and say, okay, I'm publishing my work under there's a 7cc license, CC0, which is the public domain mark. So unless I put my work and say, okay, CC0 public domain dedication, I'll now know, okay, this work is published under the public domain mark. And if I want to publish my work under CC license, same thing I need to do behind the title page of the book. I need to put out this statement that this work is licensed under the Creative Commons, whatever licenses I choose. So if someone is infringing on my copyright, we have copyright law, we have copyright commission, which are supposed to take this up. But like I said earlier, we don't take the issue of copyright so serious in this part of the world. That is why a lot of people get away with copywriting because as little as photocopying a book, let's say there's a textbook that your friend has and then you need like 3 pages or a chapter and then you just take a picture of those 3 pages, you are infringing on the copyright of that work. But because we do not take the issue of copyright very serious in a country like this, a lot of people get away with it. But if you find yourself in a country where copyright law is taken very seriously, you would be traced and then you could be sued and then be asked to pay, depending on whatever it is the owner of the creative work chooses as their penalty or those are like not criminal offenses, but then they are civil offenses. So it's not like you're going to go to jail, but then you're going to be charged, you're going to be sued. So there are laws or there are consequences, yes, to infringing copyright in a nation or a setting where copyright laws are taken seriously. So does that answer your question? Thank you. So does anybody have any other question before I go to the last part of today's? Okay, I can see one. Okay, good. Okay. What happens when someone uses a copyrighted work without reaching out to the person you mentioned photocopying? Back then in university, we were too quick to photocopy textbooks. Yes, yeah, infringing on the person's copyright. And that's the thing. A lot of people just do this ignorantly, but they said ignorance is not an excuse. A lot of people do this ignorantly because you may not even know that you're infringing on someone's copyright by taking a photocopy or taking a picture of a textbook. But that is why trainings like this are very important. That is why now you are knowing it. And now you can also train others to let them know that doing this is infringing on someone's copyright. So imagine I have a book now and I catch you photocopy my book. I can sue you and then you pay me money. I'll charge you to pay me for infringing on my copyright. But that is it. A lot of people do not know, but ignorance is not an excuse in the court of law. You are still infringing on somebody's copyright. And so the last question I'm saying, how do I know a work is copyrighted? Do we pay for our works to be copyright? No, you do not pay for your work to be copyrighted. Like I said earlier, according to Nigerian copyright law, once your work is published, it automatically comes to the copyright. So you can, if you are now choosing not to copyright your work, you could now include on the copyright page of your work that, okay, this work is published under so license and not all rights reserved to normal copyright, but you do not pay for your work to be copyrighted. The Nigerian Copyright Commission covers that. I think there's a link to it at the end of the slides. You can read it from their website. Another question. What happens when someone uses a copyrighted work without reaching out to the person? Okay, I heard that. Uh, Ideally, they don't have copyright clauses in them. I don't know if this is an answer to the question above, but if you check the title page of a book and you see all rights reserved, copyright with the copyright symbol and the year, they do have the copyright clause in them. Do not make that mistake of thinking they do not have copyright clause in them. Okay, I don't think I'm missing any. I
So,
don't think I'm
so,
missing any
so
other
if, if,
question.
if, if you put the copyright in it and somebody tears it out and you came and you didn't see the copyright in it, what happens then?
Okay, if someone tears it out, okay, like I said, even if the copyright is not there, because Nigerian copyright law gives automatic copyright to a book, you should always assume a work is copyrighted unless you can actively see on the copyright page that this work is published under another license. So because
So,
even if I publish, sorry.
yeah, like, so is there any kind of, law that says that this person actually copyrighted it, or do you have to be a company to be able to copyright? Because if you are somebody like do you just have to be a citizen of Nigeria, for instance, and the work has to be made in Nigeria?
Yes, it depends on under what law you are releasing your work. So as a Nigerian that I'm publishing my work in Nigeria, I have to follow the Nigeria copyright law. If I
So,
am a Nigerian publishing my work in like USA, I have to follow the US copyright law.
so they have to notify the Copyright Commission.
You should notify the Copyright Commission because the Copyright Commission should have a list of all published work. The Copyright Commission should I think there's like a form on their site or like something you fill or someone you contact on the Nigerian Copyright Commission's website, or you could directly go there, or you could, you know, as when you publish a work, you are mandated to submit some copies to the National Library of Nigeria, where you get your ISBN and your ISSN. So those are some of the works you can. Those are some of the steps rather you can take to solidify that okay, this work actually belongs to me, and then I own the copyright of this works. Now, like I said, automatically you have the copyright automatically, even without doing any of this. But now, if someone infringes on my copyright, what is my backing? What is my evidence that this work actually belongs to me? That is why you are advised to take all of these steps. So even without taking these steps, your work is still copyrighted. But I can argue with you that, like just like you said, if someone tears out that page now, I can argue with you that this work is not copyrighted. And then if maybe the Nigerian Copyright Commission goes to their database and then you did not inform them, or the National Library did not submit a copy of your work to them, you have no legal backing, you have nothing, you have no evidence to show me that this is your work, and I can get away with it, even if I infringe on your copyright. So we are always advised to notify the NCC to submit your work to the National Library just to give yourself an extra layer of protection when it comes to your copyright. Is that understood? Like, does that answer your question?
Yeah, yeah, it does.
Okay, thank you. So I'll just quickly go to the last part of this training, which is how to identify CC licensed work. I will be using a few of all of these that I shared earlier. So now it will show you how you can, now if I want to create my OER, maybe for my capstone project that I'm going to do at the end of this training, and I'm looking for where I can find resources that are in the public domain, resources that are copyrighted, resources that are licensed under Creative Commons license. These are some of the places I can find them, and I'll just be choosing a few. Now, the Internet Archive. Okay, before I go to the Internet Archive, for images, I can just come and say image of, okay, let me just say Nigerian universities. I go to images, and now these are a lot of images of Nigerian universities. But how I want to know images that I can use that are CC licensed and images that are copyrighted, there's like a shortcut I can do. I can come to this more, right? I click on more. Sorry, I click on tools. Sorry, not more, tools. And then I choose usage rights. And then I filter this usage rights by Creative Commons licenses. So the moment I filter it, it gives me results of pictures that are, so all of these images now, they are licensed under Creative Commons licenses. But how will I know which is which? Once I click on this one, if I scroll down a bit here, I can see where I can get this image on Wikimedia Commons, and I can see license details. If I click on license details, it tells me what license this work was published under. So now this image rather was published under CC by SA 4.0. And the good thing is, if I cannot remember what CC by SA means, I can see its attribution share alike. If I cannot remember what attribution share alike means, I just scroll down. It tells me you are free to share, adapt. It tells me what I can do under the following terms. It tells me what I can do with attribution and what I can do with share alike. I just need to read it to know. Okay, so attribution share alike, now with this image, I need to reference the original creator of the work, and then I need to share whatever adapted work under similar or same license. So it tells me what to do. I can choose, let me find another work that is not Wikimedia Commons. Okay, this is Flickr. If I click on it, I can get this image on Flickr, and I click license details. It tells me this work was published under attribution non-commercial share alike 2.0. And if I scroll down, it tells me what and what I cannot do. What I can do rather. It tells me attribution, non-commercial, and share alike. So these are just like easy ways to identify the license. First of all, you can filter your search to give you works with Creative Commons licenses. That's if you're looking for images to support your OER you're trying to create. And then you get to know what license they were released under to understand how you can use that in what situation. So back to Internet Archive. So let me just go to the home page of Internet Archive. Or let me just start from Google search. So I can just come and search for Internet Archive. Now this is if I'm looking for books, videos, visuals. Sorry. Okay. Just so Internet Archive. So this is Internet Archive. I come to its own page. Now imagine my OER is something on Nigeria's history or Africa's history. I want to create an OER on that. Maybe I want to create a textbook for government students or history students in SS2 or SS3. That's what I want to center my OER on. And I'm looking for supporting works on Africa's history. I can just come and type African history. Right? I search. Now these are a list of books that I can use, I can reference. But now I need to know what license these books were released under to know how well I can use them. So let's just take this one, Encyclopedia of African History. If I click on this book now, this is the book. It loads the view of the book. You can see it has 1,864 pages. I can flip through the pages and read them. You can increase you can magnify, use the zoom in and zoom out to read them. But now, let's say I see a chapter in this book now that rhymes exactly with what I'm looking for. But I want to do that. Can I use this work or not? I can just scroll down. Now, under publication date, I can see usage. Now, this is the license this book was published under. Attribution, non-commercial, non-derivative 4.0. Now, let's just assume again, I've forgotten what attribution, non-commercial, non-derivative means. I just click on it. It takes me to City Commons, and then I get to find out everything about the license, what attribution means, non-commercial, non-derivatives, and what I can and what I cannot do with this work. It's just that simple. Let's try another book, Writing African History. If I click on it, but then there are some that you may not necessarily find them. Yeah, exactly, like this one now. This book now, I cannot see its usage rights. Normally, if you cannot see its usage rights, when you scroll down, you're going to see its copyright. In most cases, once you can't see usage rights, under this, you see a copyright, but now I cannot see the copyright. So another thing I can do is flip to the copyright page of this work. right? That's behind the title cover. Now this is the copyright page. If I zoom in, I can see that this work is copyrighted or rights reserved 2005. So now I know that I can read through this work, right? But because it's copyrighted, I can't really use it in creating my OER because this work is copyrighted. So now that's the difference between this book and this other one. Now with this one now, I can use this work in accordance to the conditions of the work because it is a CC licensed work. So this is the advantages of using CC license. It gives others a kind of free part, not really free because there are still conditions you have to meet, but it's more open. It's not as restrictive as it's not as restrictive as all rights reserved copyright. Let's just check another one, Encyclopedia of African History and Culture. Let's see. I also cannot see its usage rights. So most likely it's going to be copyrighted. I scroll to the copyright page. I zoom in to try and see it. And then I can see copyright 2005, 2001. So for every book you see, you get to know how it is you can or you cannot use that. You can or you cannot use that work. So that is for Internet Archive. Another one I spoke about is Wikimedia Commons. And the good thing with Wikimedia Commons is every single work on Wikimedia Commons are CC licensed. So, with Internet Archive, we're seeing some that are copyrighted. With Wikimedia Commons, they are all CC licensed. So, same thing I did. If I want to use Wikimedia Commons, I just come Wikimedia Commons. No, this is Wikimedia UK. I go to the home page of Wikimedia Commons. Same thing, I'm looking for books on African history. I search for African history. Now I'll see images, I'll see audio, I'll see videos, and then if I'm looking for books, I come to other media, I see books. So Roman African outline of blah blah blah. A story of let's imagine I want to use this, the story of African explorers. I click on it. So this is also the book. Same way I can download this if I want, and then I can flip using this next page. I flip it. It takes me to the next page, previous page, next page. I can keep flipping to all the other pages. And then if I just scroll down, I'll see the license. So now licensing, under licensing, this work is in the public domain in its country of origin and other countries area, which the copyright term is the author's life plus 100 years. Now, Nigeria's copyright law is the author's life plus 70 years. With the US copyright, it's the author's life plus 100 years. So meaning this work is in the public domain, even in the US. So now with this work now, I can use it. In fact, I do not have to reference the owner of this work. I don't have to reference the Smithsonian Institution Libraries or whoever it is that wrote it, Russell, E-Trade. I don't need to reference Brown Roberts, who is the person that wrote this work. I do not have to reference the public, I think this is the public published as Russell E-Train Africana Collection. I do not have to reference them because this work is in the public domain. So let's try and find another one, another work. Records for the early history of South Africa. I click on it. I scroll down to licensing. Licensing, this work is in the public domain. I can see this work is also in the public domain. So works on Creative Commons, you will not even see any work that is copyrighted, either public domain or, okay, let's do Nigerian history. Let's do something on Nigeria. Nigerian history. It's either going to be public domain work or CC licensed work. Political transitions in Nigeria, 1993 2003. So let's see. This work, public domain, is also in the public domain. I'm trying to find a work that is CC licensed because everything we've been seeing is public domain. Let's see this on the effects of Boko Haram on the church in Nigeria. Okay, yes. So now this work under licensing, this file is licensed under Creative Commons attribution. So CC BY 4.0. And just like always, if I can't remember what it is, and all I need to do is click on the license and to take me to the 60 license to help me understand what I can or cannot do with this work. And so another one, I'll just do like two more before we bring this to an end. Europeana, let's see, with Europeana, I can just do the same thing. Go on Google, search for Europeana. Okay, Europeana. Okay, and so I also look for African history. Okay, this how works. South African history in perspective. Let me just click on this one. If I'm trying to know what license this was published in, okay, I can already see it in copyright. So this work is copyrighted. This is the right thing. Once you read the right statement. In copyright means you may be able to use this item if you seek permission. So you have to reach out to the author of this work to understand what and what you can and what you cannot do, or to seek permission for what you can do. It's not even what you can do, sorry, because you cannot use it without permission from the author. South Africa's, okay, let's do Nigerian history instead. Let's just a lot of Nigerian history. Okay. Africa's education enigma, the Nigerian story. Okay. So if I come to all metadata now, okay, so right statements for this media. This is the right statement. Now, this is not a Creative Commons license. This is a different type of open license, but all I can just do is, because I do not understand it, it's a link. I can copy the link and then just paste it, and then I get to understand what I can do with the work. So this is a copyrighted work. It's in copyright. So for every you either see a link or you see, okay, it's even up here in copyright. So this work is copyrighted. Let's try and find a work that is not copyrighted. Nigeria's essay is also copyrighted. I'm trying to find something that is not copyrighted. In copyright also. Let's do Africa's history. I think with Africa's history I can find some. But like there are a lot because this is just like one page out of 42. So and then I'm just searching. You can select your theme depending on what you're looking for. Depending on what it is you're looking for, the type of media. Is it sound, text, video, 3D? I'm just trying to find just a random work that is not copyrighted. So that you see our South Africa Journal or so all metadata. So okay, so this is the right statement. Creative Commons public domain mark. So this work is in public domain. If I want to understand what it means, all I need to do is copy the link, come back here, paste the link, and then understand public domain mark is a CC public domain mark. So I get to say that there's no copyright in, so I can use it in any way. So if it was a CC licensed book, I would also see how, what license or what conditions I can use that work on. And then just lastly, very quickly, I would do the last one, which is public domain.ng. This is a project that is work that public Free Knowledge Africa is working on to try and create public domain. Sorry, public domain.ng. to try and create public domain works in Nigeria. Yeah, so this is public domain enjoy free access to public domain works. So this is a pioneer project by our organization, Free Nigeria Africa, and you could see Nigerian newspapers that are in the public domain, Nigerian government publication, Nigerian pictures, books, and public figure portraits. And this all links us to Wikimedia Commons. So if I click on Nigerian newspapers in the public domain, it takes me to a collection of newspapers that are in the Nigerian public domain that I can use, public domain now without restriction. So I want to view the collection, it now directs me to Wikimedia Commons under a category PD Nigeria newspapers. And then I can see a lot of newspapers that I can use freely because they're all in the public domain. Different newspapers, West African Pilot, Daily Comet, Daily Times, Star, Nigerian Spokesman. Can see the year 1955, 1965, 1961. You have 1940s, we have 1960s, 1950s, 1970s. And same thing with images. I want to see some images that are in the public domain. And all of these are like sites that could help you when trying to create your OER. You're looking for where to get resources, where to get materials, to get images from. These are some of the sites that could help you view now. So this is the category PD Nigeria images. These are a lot of images that are in the Nigerian public domain that could help you in creating your OER. So I think we've come to the end of today's session. We have 5 more minutes. I'll just leave that for a few questions. These slides will be shared with you. These are some links, some sites you could go through. With all of these, I just showed the example of a few of them. We still have the public domain review. You could check them out. You could find works that are in the public domain that are CC licensed. Project Gutenberg, Flickr Commons, Europeana Library of Congress. You can check them all out. You can find a lot of works that could help you in creating OERs. And these are some links that you can read to be able to get more insight on public domain. So I'm seeing a few questions. Not actually. Is it only for pictures or images, or which documents in PDF format inclusive? I don't know if you're trying to ask about public domain or CC licensed works. Whether it's a picture or an image, whether it's a book, whether it's a sound recording, a video or audio, in as far as the creative works, they have licenses that are attached to them. So these works, they could either be public domain. It does not have to necessarily be in PDF. They could be in JPEG, that's for images. They could be in DJVU, which is also a text document. They could be in MP3, MP4 for audio and videos. It does not matter the format. It's just the creative work itself. It could be CC licensed or in the public domain or copyrighted. I don't know if this answers your question, Bolu. What exactly does the 2.0 or 4.0 added to the CC license means? These are like versions of the licenses. So when you click on them and then you get to the usage rights page, you get to see. So for 1.0, there was like a newer version, some things that were changed, some things that were added to the 2.0. Now, the conditions are still the same. CC BY its attribution, but then there are some certain revisions that were made, which is why you have 1.0, 2.0, 3.0. I think the latest that we have so far is 4.0. So these are just like versions or like improvements on the licenses. What about citing? How does that work? So for citing a CC, a copyrighted work, you have to put the author. So for citing if like in a journal now, in a research work, literature review, you put, depending on the citation style you're using, if it's APA, if it's Harvard, if it's or Scholar, you put in, depending on the style, the name and the year. So it's also similar to that, but with Creative Commons licenses, you need to put in the person, the owner of the work, the year, and the license. That's the one thing you add when citing a CC license group. So imagine you're using my work now that is licensed CC by SE. You put Olubusola Afolabi 2025 in brackets CC by SE. So that's the addition with Creative Commons works. You have to add the license, and if possible, you link that license so that anybody that is seeing, it just be easier for the person to click on that link and then take me to the Creative Commons website where I can get to read all the conditions that are attached to the license. Good evening, I have to leave. Shoma Beto. Okay, thank you. Please, will the recording of the lecture be made available to us? Yes, it will be. Okay, someone has answered. Could you list other licensed organizations just like Creative Commons? Yes, I know we have Flickr Commons. There's this other one that we were seeing. On this, there was one other one. I think I see something. Let me try and find it. I mean, Creative Commons is one of the popular ones that a lot of people know about, a lot of people use. But yes, aside Creative Commons license, there are other open licenses that we have. Trying to find one that I saw recently, just now. This is also public domain. Oh, we could just even search open licenses. Other open licenses for intellectual materials. No? Okay, so we see we have Creative Commons. Copyleft is the same as public domain. The same we have copyright, which is all rights reserved. We have copyleft, which is um no rights, no rights reserved. Copyleft. Okay, this only shows Creative Commons and copy. I know they are Flickr Common licenses. I would add a link on this our slides to the further readings so that there will be a link where you could access the other open licenses that you could use. And then I'm very sure if you click on the link to those licenses, you'll be able to see the conditions by which you could use and you could use them. Okay, you can see one MIT licenses. I'm very sure they also have different conditions on how you can or cannot use them. So I don't know if there are any other questions, you could put them on our WhatsApp platform and then we'll be always ready to answer our questions. So we're already 1 minute past our time. Thank you everybody for joining. I would encourage us all to check out all our social media platforms. We are FreeMage Africa on YouTube, on Instagram, on Twitter, on Facebook. Yes, you can check out all the works we've previously done. I mean, you could get a lot of inspirations from works we've previously done. You can visit our website, our blog post. You would see a lot of things we've done, and you could get inspiration on capstone projects you could do. So check us out, FreeMage Africa, on Instagram, X, Facebook, YouTube, our website, freemageafrica.org. And we look forward to seeing you guys next week, Saturday, where we'll get to talk about another interesting topic with another very seasoned professional. So thank you all for joining and staying to the end of today's class. And I wish you guys a happy weekend. Thank you.